Thank you very much. My name is Caroline Pounds. I'm a barrister at Quadrant Chambers and I've been practicing commercial law for nearly 18 years. The title of this QBiT is What is Estoppel by Convention? Well, it's something that the Supreme Court has described as notoriously difficult to pin down. Thankfully, I like a challenge, and so I'm going to explain it to you in under 10 minutes. In order to do that, I'm going to answer 3 questions. First, what is estoppel by convention in overview? Second, what are its requirements? Third, and no doubt of most interest to clients, what is its effect? So what is it, first of all? Well, it's an English common law principle whereby parties to a transaction who have acted on a common assumption that a given state of facts or law is true may be prevented, i.e. stopped, from resiling from that assumption and from asserting, as against the other party, the true facts or position in law. Now, it's a principle which applies to both contractual but also non-contractual dealings. One more normally comes across it in the context of a contract, at least in my area of practice, but there are a number of authoritative decisions which consider its application in the non-contractual context. One of those decisions is that of the Supreme Court in Tinkler and HMRC. Let me tell you a little bit about that decision. HMRC commenced an inquiry into Mr. Tinkler's tax return. Notice of that inquiry was required to be sent to Mr. Tinkler, but was sent to the wrong address. Notice was also sent, however, to Mr. Tinkler's accountant, who was authorised to act on his behalf in his dealings with HMRC. There then followed considerable correspondence between HMRC and Mr. Tinkler's accountant in relation to the inquiry. HMRC raised certain questions about property transactions and certain capital gains. Mr. Tinkler's accountant, on the other hand, indicated that there were further losses that should have been included in the tax return, which was now, he said, the subject of an inquiry. Ultimately, HMRC issued a closure notice claiming £70,000 from Mr. Tinkler. Mr. Tinkler appealed that decision, and one of the points he sought to take on his appeal was to rely on the lack of valid notice of inquiry. The matter went all the way to the Supreme Court, and the Supreme Court held that Mr. Tinkler was stopped by convention from taking any point about the validity of the original notice. Now, in reaching its decision, the Supreme Court provided clarification as to the requirements of estoppel by convention. It also helpfully confirmed that the same requirements apply whether one's dealing with an estoppel by convention in the contractual context or in the context of non-contractual dealings. Now, there are nuances to all of the requirements, but they are essentially 3, and query whether there's a 4th. First requirement, there must be a shared common assumption. Second, there must be reliance on that shared common assumption. Third, there must be some detriment suffered or benefit conferred by the person alleging the estoppel. Query, as we'll see, whether there's then a further requirement of unconscionability. So let's take the first requirement, that of the common assumption. This is the most nebulous of all of them and often the most difficult to satisfy. Unlike other estoppels, estoppel by convention is not dependent on any representation or promise. The cornerstone of estoppel by convention is instead that of a clear and unequivocal assumed state of facts or law. For example, that valid notice of the inquiry had been given in Tinkler. Now, that shared common assumption is critical, but it's really important to remember that it's not sufficient in and of itself. What do I mean by that? Well, it's not enough, for example, that the common assumption is simply understood in the same way, or that each of 2 parties acts on an assumption which is not actually communicated to the other party. Rather, what is required is that the assumption must be expressly shared between the parties. Now, it can be shared by way of their words or by way of their conduct, but the critical point is that the words or conduct must be shown, in the language of the authorities, to have crossed the line in a manner sufficient to manifest an assent to the assumption. It's also necessary that the expression of the common assumption by the party estopped is such that he may be said to have assumed some element of responsibility for it, in the sense of conveying to the other party an understanding that he expected that other party to rely on it. Moving then to the second requirement of reliance. Thankfully, this is rather easier to deal with because it's what it says on the tin. The key point is that the party alleging the estoppel must in fact have relied upon the common assumption, as opposed to, for example, his or her own independent view of the matter. The test is similar to that of inducement in a misrepresentation claim, which many of you will no doubt be familiar with. It's also necessary that the reliance must have occurred in connection with some subsequent mutual dealing between the parties. So, for example, going back to Tinkler, there were the mutual dealings, mutual exchanges between HMRC and Mr. Tinkler's accountant. We come then to the third requirement, that of detriment or benefit. What do I mean by that? Well, some detriment must have been suffered by the person alleging the estoppel, or some benefit conferred upon the person alleged to be estopped. Now, if you were pleading this out and sitting typing away, you perhaps go on to say, such that it would be unconscionable for the parties to go back on the common assumption. Query, however, whether unconscionability is actually a further requirement. What the Supreme Court in Tinkler and HMRC said was this: unconscionability is unlikely to add anything once the other elements of estoppel by convention have been established, and in particular, where it has been established that the estoppel raiser has detrimentally relied on the common assumption. The court recognised that there might be exceptional cases. So, for example, take the situation where there were fraudulent conduct on the part of the estoppel raiser. Such cases, however, are likely to be the exception rather than the rule. And so assume you've jumped through all of those hurdles. You've got your shared common assumption, you've got your detriment, and you've got your reliance. What is the effect of all of this? Well, the effect in a nutshell is that estoppel by convention serves to preclude a party from disputing the truth of the shared common assumption, regardless of its correctness. 3 limitations to note. First, its effect is limited to the transaction under which the assumption arose. Second, it is of retrospective effect only, and so it will not apply to future dealings once the common assumption is shown to have been erroneous. Third, like other estoppels, that well-known phrase, it operates as a shield and not a sword, and therefore doesn't create a cause of action. Now, there's considerable scope for debate there, and it's all rather murky, because it's not easy to draw the line between enlarging the effect of an agreement, which the courts have allowed, and creating an enforceable right where one would not otherwise exist, on the other hand. That debate aside, we'd have to have more time to go into that, what is very clear is that estoppel by convention can have far-reaching effects and can operate significantly to alter the obligations of a party pursuant to a contract. Let me give you a few examples. It can preclude a party from relying on the true construction of a contract and serve to bind that party to an alternative interpretation to that which the words would otherwise bear. It can therefore affect, for example, the amount payable under a contract. It can deprive a party of a defence so as to enable a claimant to win an action which it would otherwise have lost. Similarly, it can enable a claimant to succeed on a cause of action on which, without being able to rely on the estoppel, it would necessarily have failed. And so to sum up, whilst its requirements are difficult to establish, where they can be made out, estoppel by convention can be a very powerful weapon indeed. I hope that answers the question, what is estoppel by convention? Thank you very much.